SB number 1558 by Perry relating to the liability of nonprofit entities contract with the Department of Family and Protective Services or with a single source.
Passes third reading. Chair lays out on second reading Senate Bill 1558. Clerk, read the bill.
SB number 1558 by Perry relating to the liability of nonprofit entities contract with the Department of Family and Protective Services or with a single source continuum contractor to provide community-based care or child welfare services.
Dr. Bonin.
Thank you, Mr. Speaker. Foster care providers are required by contract and by state law to carry liability insurance coverage. However, these providers are experiencing skyrocketing insurance premiums.
Gonzalez, will purpose.
Does the gentleman yield for questions?
No, I don't. I'm
Not at
going to
this time.
finish my layout. Limited carrier availability and burdensome policy changes. This legislation clarifies existing law to provide separation between good providers who want to serve children in our foster care system and the perpetrators who harm children or contribute to the harm without any previous indication that they would do so. Without clarification in Texas law, Texas, like other states around the country, risks leaving thousands of children without placement and destabilizing our foster care system. This legislation reinforces the existing protections of the Charitable Immunity and Liability Act to make it clear that a nonprofit foster care provider and the nonprofit single source continuum contractors who provide community-based care are protected by the Charitable Immunity and Liability Act. This clarification will give clear direction for insurers so that providers can access more options for the required liability insurance coverage. Further, this establishes what foster care providers must do to be determined to be in good standing, meaning they have taken appropriate actions to ensure that background and registry checks, training, and necessary reporting or personnel actions have occurred. This will ensure that those who harm or directly contribute to the harm of a child continue to be liable while providing some separation for providers when nothing in due diligence process indicated or suggested that harm would come to a child. This legislation clarifies immunity for groups currently included under the Charitable Immunity and Liability Act, and it does not extend any protections to for-profit entities. This legislation does not provide additional protection for those who harm or directly contribute to harming children in foster care, and this legislation does not change who can sue for damages and does not modify the statute of limitations on any suits. There's a very serious concern that without legislative action, foster care providers will not be able to provide appropriate liability insurance coverage, which they are required to have by law, and children will be without necessary foster care placement.
Mr. Speaker,
Ms. Gonzalez, will purpose.
does the gentleman now yield
Gentleman yield for questions.
Yes.
He yields for questions.
Thank you, Dr. Bonin. And I know this bill came through JCJ, which I serve on, and so just have a few questions. So in your bill, it provides for certain immunities to nonprofit entities and their staffers under specified conditions, correct?
Yes.
Could you clarify the rationale behind offering such broad immunity, especially in relation to statutory requirements for maintaining in good standing?
Yeah, so let's be clear, the immunity is actually not broad. We're talking about vicarious liability, and they're only protected from that if they meet very specific requirements. Specifically, they must have conducted timely criminal background checks for the employee as required by law before hiring, contracting with, or otherwise enlisting the services of the person, and then at least once every 5 years they have to have confirmed the person is not listed in a state registry or database that indicates the person is ineligible to supervise or treat children. They must have reported any known allegation of misconduct by the person as required by law. They must have taken timely and proportionate administrative or personnel action in response to deficiency in the performance of duties by the individual, and required the person to complete training for A, child sexual abuse prevention at least once every 5 years, and B, the reporting of child abuse and neglect. Additionally, with respect to any given incident, the entity was, in order to not have this protection, they have to have not been in substantial compliance with the requirements that were described, and the requirement had to have been designed to prevent the specific type of harm that was alleged to have occurred.
So you kind of answered my next question. You mentioned substantial compliance. Was that the list that the items that you just mentioned?
Yeah,
that they had to? Okay.
That is the list, and then I was going through another section, and there's some other elements that they also have to meet.
Okay, so it has these specific guidelines that they have to meet laid out in your bill.
Correct.
Correct. Okay.
They have to be compliant with these.
Okay.
Substantially compliant.
Okay. And so what's substantial? I mean, who determines if it's substantial or not?
Yeah, this would be important in a court of law if there was a case, and the difference here obviously being substantial compliance, meaning that they have complied with the law, whereas if it's not substantial compliance, then even a technical deficiency could potentially open them up to liability.
Okay, so this bill, it limits liability except in cases of gross negligence, correct?
Correct, that's right.
So does granting immunity to nonprofits except in cases of gross negligence, do you think that risks prioritizing organizational protection over the safety and rights of service recipients?
I think we've gone to great lengths to make sure that these providers are fully following the guidelines that have been set out to protect kids.
Thank you, Dr. Bonin.
Following amendment, clerk will read the amendment.
Amendment by Dutton.
Mr. Dutton.
Thank you, Mr. Speaker. I think this makes this bill a little better because I think the questions that were just asked had to do with substantial compliance. We require the providers to do certain things to get the immunity on one hand, and on the other hand, we say if they substantially comply, they can get the immunity. That's to me is going to cause more lawsuits about what substantial compliance means. And so what my amendment does is simply take the word substantial out so that either the provider complied with the requirements we gave them or they didn't. And that won't lead to many arguments. And so I move adoption of the amendment.
Mr. Speaker,
Ms. Gonzalez, will purpose?
does gentleman yield for a quick
Gentleman have
question?
questions? He
Yes.
yields for questions.
So
Yes.
I just looked at your amendment. So your bill or your amendment took out substantial. So now a person, or I guess an entity or what have you, would have to comply with all the
Correct.
factors that are laid out.
Correct.
Okay, thank you.
So that we don't have an argument about what substantial is. It's kind of like, you know, the Ten Commandments. Either you complied with them or you didn't.
Yes.
And I don't think the good Lord would let us substantially comply.
I agree. Good amendment. I'll be supporting it.
All right, thank you.
Dr. Bonin in opposition.
Yeah, members, this is actually really important. The providers would still have to be substantially compliant with all of the elements. What this is saying is that even if they had materially and substantively done everything they were supposed to do on a technical error or omission, such as not having an appropriate date, they could be then exposed to vicarious liability. That is a big change, and so I'm opposing this amendment, and I move to table.
Mr. Dutton to close.
Members, nowhere else on the law do we grant immunity and then say that all you have to do is substantially comply to get that immunity. Nowhere else in the law does that happen. You either comply with the terms or you don't comply with the terms. And what this is going to do is lead to more lawsuits because the lawsuits are going to be about whether you substantially complied or not. That's not a defined term, and so it is going to be difficult to determine whether or not there's substantial compliance or not. That's going to be a fact issue, and the fact issues are going to go to the jury, for the jury to decide. And I don't think this bill ought to create more lawsuits. I agree with what he's doing. I just want to take the uncertainty out of it. And the uncertainty that exists now is whether or not a provider substantially complied. That's all there is to it. I don't think we ought to leave anything uncertain about whether or not they've complied. And to leave the term substantial in there means that we're going to be saying, well, we're not sure whether you complied or not. And so what my amendment does, it says that here are the terms you have to complete. Here's the things that we said you have to do. And if you do them, you get the immunity. And if you don't do them, you simply don't get the immunity. And I don't know why that would be so difficult, but I think as a lawyer, I really don't want any more lawsuits than we need to, especially around things that we could have settled in this chamber. And so I would ask you to vote no on the motion, no on the motion to table. That's no on the motion to table to make sure that substantial compliance is out of this bill, and either the providers complied or they did not.
Record vote on the motion to table. Clerk, ring the bell. Show Dr. Bonin voting aye, Mr. Harris voting aye, Mr. Dutton voting nay, Mr. Busey voting nay, Mr. Vasut voting aye, Mr. Leach voting aye. Have all members voted? Have all members voted? 86 ayes, 56 nays. The motion to table fails. Dr. Bonin.
Move passage.
Question occurs on passage third reading. Record vote. Clerk, ring the bell. Have all members voted? Have all members voted? Shaheen voting aye, Vasut voting aye, Tinderholt voting aye. 94 ayes, 49 nays. Senate Bill 1558 passed third reading.